All right, folks, welcome back. We are joined right now by our friend, civil rights attorney Gloria Allred, who filed a friend of the court brief on behalf of the Women's Equal Rights Legal Defense and Education Fund in the Prop 8 case that was decided today by the U.S. Supreme Court. She also filed the lawsuit on behalf of her clients, Tyler and Diane Olsen, who were the first in California in 2004 to announce they would file a suit challenging the ban on same-sex marriage. Then after that, Prop 8 was passed, and we are where we are today. Hello, Gloria. How are you?
Just fine, thank you.
So,
thank you for inviting me, Steve. It's a great and historic day, and I would just add one thing to what you just said in your kind introduction, which was that not only did we announce that we would challenge the law, but we did challenge the ban on same-gender marriage in California, and we won at the first time at the California Supreme Court, and that's when they found that the ban was unconstitutional, after which our clients, Robin and Diane, were able to get married and become the first in L.A. County to be able to marry, as well as 18,000 other couples were able to marry. And then after that, that's when Prop 8 was passed in California by the voters, and then it went back to the Supreme Court. We filed a writ with the Supreme Court to challenge Prop 8, but unfortunately they upheld it, and that's when they stopped the marriages, although they did agree with our argument that the 18,000 couples who had already married, that their marriages would remain valid.
All right, so where are we now? Because the Supreme Court basically vacated the appellate court's upholding of the district court in California. And the people who were in court fighting this or were trying to protect Prop 8, the Alliance Defending Freedom attorneys, say that the California state constitution dictates that for Prop 8 to be overturned or ruled invalid, it has to be an appellate court that does that. That decision has now been vacated, so it's just a single court judge that has ruled, and that ruling counts. So they're saying to the governor, not so fast, you can't start printing up those marriage certificates yet.
Well, that's what they may be saying to the governor, but the governor's either not listening or disagreeing with them, because I'm looking at a press release issued by the governor just in the last couple hours regarding Prop 8, in which he says, I have directed the California Department of Public Health to advise the state's counties that they must begin issuing marriage licenses to same-sex couples in California as soon as the Ninth Circuit confirms the stay is lifted. And he says, I won't read the whole thing, but essentially he's saying that he sought an opinion from the California Attorney General on whether the state can advise county clerks and registrars that they're bound by the federal district court's ruling that Prop 8 is unconstitutional. And then he goes on to say the Attorney General concluded that the California Department of Public Health, quote, can and should, end quote, instruct county officials that they must resume issuing marriage licenses to and recording the marriages of same-sex couples.
So with that aside, and I'm sure there's going to be more court action, whether or not that prohibits the ballots from actually being not the ballots, but the certificates from being handed out is another matter. So you favor five men and women in Washington overruling, or 5 men and women anywhere, or 3 men and women, or whatever, overruling the will of the people of a state?
Well, they're not men and women, just men and women. I mean, they're the justices of the United States Supreme Court, the highest court in our land. And essentially, though, they didn't get to the merits of
No. But I mean, in general, obviously they punted this back. But
they on the standing issue,
right?
Because there was nobody to really present the other argument except the proponents of Prop 8, and that was not, as a matter of law, sufficient.
And by the way, they use a double standard, from what I understand, because in the past they've denied Congress standing in cases, yet they let Congress's standing remain in DOMA. So there's some discussion about why they implied a double standard on standing in the two cases. But nonetheless, where do you think we go from here on Prop 8? I mean, you think it's full steam ahead for your clients and everybody else?
Well, yeah, my clients are married. They continue to be married, and very happy that they are married. And
because they fit in before Prop 8, right?
Because they fit in before Prop 8, yeah. Well, they married.
That's what I mean.
Prop 8, yes. But now this is essentially a joyous new beginning for the civil rights movement in general, and for gay rights in particular. And we're thrilled that same-sex couples in California will once again be allowed to marry as soon as the Ninth Circuit stay is lifted. And they'll finally have, because the DOMA Defense of Marriage Act was found to be unconstitutional today. These couples will finally have all of the more than 1,000 federal benefits enjoyed by heterosexual married couples because DOMA is unconstitutional, no longer the law of the land.
We got a minute, but let me ask you one question. If this was such an awful law, why didn't, in the 2 years that Obama was president, Pelosi was speaker, and they controlled the Senate, why didn't they try to overturn DOMA in the 2 years that Obama, when Obama became president?
I don't speak for the president, so I really can't tell you why he did or didn't do what he did or didn't do. But I can tell you there's obviously no way that this would have gotten through the House of Representatives, which is controlled by Republicans.
No, it was all Democrat when he took office for 2 years. Anyway, Gloria, I guess I'll say congratulations to you, and I thank you for your time. We're up against a hard break. Thank you, Gloria Allred, ladies and gentlemen.